How was the test today? How do you remember your schedules? Years of old PM. Still the same thing is being followed then. தெரியுமா எல்லாருக்கும் தெரியுமா No. Okay. There are totally 12 schedules, right? So how do you remember the 12 schedules? Is like you remember like tiers of old PM. That is a trick which is like very age old trick. It is like it starts with tiers. TEARS. Tiers. So what does T stands for? Territories. Okay. Then E stands for emoluments. Salary or emoluments. தெரியாதுல்ல எழுதுங்க emoluments. Then A stands for oaths and affirmations. Okay. Then R, Rajya Sabha seat allocation. Then S, scheduled tribes. Next O, other schedule areas. Then F, federalist. Then of old O, official languages. L, land reforms, which is actually the times one. Okay. D, anti-defection. D is actually anti-defection. Defection, அந்த D use பண்ணிருப்போம். Then P, panchayats, and M is for municipalities. Initially, how many schedules were there? Later 12. So when was the first schedule? That is 9th schedule introduced. 10th one. 52nd Constitutional Amendment Act. Okay, next up. Panchayats, that is 11th. 12th one. Done. Okay, we shall start. See, from 2015 onwards, if you have taken like around 4 questions have come from the schedules alone. And it is not too difficult for you to answer. It is very simple. Majorly, the questions came from the first schedule and then the 9th one and 5th and 6th schedule. Only these schedules have been, the questions came from. And to start with, which schedule contains provisions relating to the emoluments, allowances, and privileges to the president and the governor? Second one. It is as simple as that. Yes. Next up. If a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statements best reflects the consequence of it? See, in this like 4 statements are there, right? But only one statement talk about the tribal areas and stuffs. And 5th schedule is related to tribal areas. So UPSC put the questions in such a manner, it is very simple. Still, they didn't go next step. The further step, they didn't go yet. So these questions are very simple. You don't have to think much. Okay. So what in 5th schedule, what are the states included? Hey, one second. Okay. What are not included? Okay, leave it. Okay, go to the third question. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? 5th schedule. This is a question that came in UPSC just like this. Okay, so when questions from schedule comes, this is how the questions have been for the past like 5-7 years. The question is like this only with respect to schedules. They didn't go any further steps. Okay. Now this one. The provisions in 5th and 6th schedule in the Constitution of India are made in order to protect simple scheduled tribes. Yes, especially I remember it like Assam la 3 nimisham mala. I have already told you this. Assam 3, Tripura nimisham. I keep that as Mizoram and Mala Meghalaya. I keep like that. I don't think much. Okay, rather than keeping it in some other meanings, I keep it like this. So those who don't know, you can have this. Others, you follow what you are following. Okay. Next one, 5th one. See, with respect to 9th schedule, if you look into that was brought through the first Constitutional Amendment Act, you must be knowing. That is the 9th schedule came through the first Constitutional Amendment Act. Because back then, like no one was very cared about which schedule, which amendment act. And the question was under whose prime ministership this amendment came into being or the schedule was introduced. So now what happens? It's better, after this 9, 10 and this Panchayat municipalities there, right? Just know under the prime ministership who was there or the president, just know what it happened and a little bit of background about it. Okay, especially with local self-government, right? There were certain committees were formed. Balwant Rai Mehta committee, Ashok Dutt. Okay, just to know what are the committees associated with local self-government. Just know about those committees. Already it is being clearly given, but just know what they told. Because it is, you don't have to look into whether it is whether they recommended 3-tier or 2-tier, not too much into that, but at least know how it actually progressed to this constitutional amendment. That is more than sufficient. Okay. Next, sixth one. With reference to the 9th schedule of the Indian Constitution, consider the following statements. It was the first schedule that was added after the commencement of the Constitution. Yes, first constitutional amendment. It was enacted to protect laws related to agrarian reforms and for abolishing the zamindari system. Yes. Then all laws placed under the schedule are provided immunity from judicial review. Okay, that is a cutoff date, right? Just remember that alone. See, when the statement is asked plain like this, don't think that those laws are protected from judicial review, so I will make it as correct. Don't think like this. This is very plain statement. So the statement becomes strong. Whereas you must know the cutoff date and the case associated with that. That is Keshavananda Bharti case and what is the date? 24th April? Yes. Next, seventh one. Which one of the following schedules of the Constitution of India contain provisions regarding anti-defection? First itself we have talked about, it is like 3 years of old PM. So old D stands for anti-defection, which is 10th schedule. And which is the year? ஒரு முடிவுக்கு வாங்க 19 விட்டுருங்க அதுக்கப்புறம் இருக்க மாட்டோம் 85 okay. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of the fundamental rights? See, this is like a very subjective question. It is like both First Amendment and the 42nd Amendment both are right, and UPSC dropped this question because I gave 42nd Amendment, others gave like First Amendment, so it was like that. And that time, like it was like widely discussed during that time. Like 23, this question came, I think 23 or 23, this question came, and UPSC dropped this question. When there is like two answers, UPSC tend to drop that question. No doubt about that. Okay. So this is both First and 42nd Amendment Act. Now, answer is both A and B are right for this question. See, with respect to this, the first constitutional amendment act for the it invalidated on the ground of the contravention and the fundamental rights conferred by Article 14 and 19. So that is one of the reasons why. Wait a minute. Okay. So all these articles were actually added mainly for this purpose, for judicial interpretations. So they added, that is with respect to first constitutional amendment. And with respect to 42nd, see, it extended the scope of Article 31C again. So both these amendments related to fundamental rights and with respect to the judicial interpretations. That's why both the statements, like both the amendments are right. See here, by including within its protection or any law to implement any of the directive principles cannot be void. That is what this amendment gave. Okay, so that is why in this question, both First Amendment and 42nd Amendment both are right. Clear? Okay, this question, the answer what is given is wrong. The answer is the principle of natural justice. Okay, in essence, what does due process of law means? Due process of law, which case law it came into in India? See, it is a judicial interpretation. We just follow this procedure established by law. Only in this Menaka Gandhi case, the Supreme Court interpreted that due process of law should be followed. And in due process of law, we say then the principle of natural justice comes into place. It is not just the procedure, whether the procedure is also is like whether we are following all the process and whether it is rational. All these things will be checked in this principle of natural justice or this due process of law. Clear? Principle of natural justice is the answer. அதுல தப்பு ஃபர்ஸ்ட் எடுத்த உடனே அதை தான் சொன்னேன். Okay, which of the following are regarded as the main features of the rule of law? Limitations of power, equality before law, people's responsibility to the government, liberty and civil rights. Can the people's responsibility to the government is what? It is a duty, right? It is not a rule of law. Okay. Clear? Any doubt in this? Why limitation of powers is included? Is in rule of law? If you are clear, I am okay with that. Okay, வேற ஏதாவது ஆப்ஷன் போட்டிருக்கீங்களா அதுக்கு? 1B. D, okay, அதுக்கு நான் சொல்லிட்டேன். People's responsibility to the government is a duty. It is not rule of law. Okay, the rule of law index is released by which of the following? See, what is India's rank in that? What is India's rank in rule of law index? பாத்தியா? இல்ல அப்புறம் சும்மா அடிச்சிடுற. See, it is 79 out of 142 countries. It is 79th rank. Okay. And there are around 8 indicators. You can write it down. What are those 8 indicators? The first one is constraints on government powers. Constraints on government powers. First one. The second one is absence of corruption. Absence of corruption. Third one is open government. Open government. Fourth one is fundamental rights. Next, order and security. Order and security. Order and security. Then regulatory enforcement. Regulatory enforcement. Civil justice and criminal justice. Civil justice and criminal justice. See, within South Asia, India ranked 3rd. Within South Asia, India ranked 3rd. First, Nepal is in 69, Sri Lanka is 75th, and the 3rd place is to India. Okay? Clear? Okay, the next one, 12th question. Consider the following statements with reference to fundamental rights. இதுல எல்லாத்துலயுமே all, any, no எல்லாம் இருக்கு. Okay? All the fundamental rights are justiciable. Yes. All the fundamental rights are available to both the citizens and foreigners. Which are available only to citizens? Yes, it is 15, 16, 19, 29 and 30. Only these articles are available only to citizens. The rest of the articles are available to both the citizens as well as the foreigners or aliens. Okay, the parliament has no power to amend any of the fundamental rights. No, they have the power to do that. Then the parliament has the power to suspend all the fundamental rights when an emergency is declared. Okay, under what circumstances? External It restricted the scope of Article 358 in two ways. Firstly, the 6 fundamental rights under Article 19 can be suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. That is one thing. And okay, that is, you can keep with that. Then the president cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Article 20 to 21. And in other words, the right to protection in respect of conviction for offences, Article 20, and the right to life and personal liberty remain enforceable even during emergency. See, this year this becomes very important. Okay, because like November, December, this parliamentary session, we had a special session for this, like talking about this emergency itself. So this is 50th year too. Yes, right? So it's very important. So know about this. Since they haven't asked yet, it becomes much more important. They can link fundamental rights and emergency. Okay. புரிஞ்சதுல ஏதாவது டவுட்ஸ் இருக்கா? Okay. Then with respect to this 13th question, which of the fundamental rights is only available to the citizen, is available only to the citizens and not to foreigners? Okay. So you must be knowing, see, for fundamental rights, DPSP, try to remember the article and the provisions. Okay, don't try to omit it. You have to memorize it no matter what. At least you know this article is related to this. Not the exact wordings. At least know this article comes, Article 19, what it is, Article 17, what it is, something like that, you remember it. Okay, no matter what. Because like if the questions come in this manner, you might be remembering by like Article 15, 16, 19, 29 and 30. You must be knowing what is Article 16 and 29. Likewise, if you didn't know and the question won't come like that, they'll just keep this give single statement like that. So that shouldn't be a hindrance for you to get that answer. Clear? Next, 14th one. Consider the following statements regarding fundamental rights and legal rights. Both legal rights and fundamental rights are protected by the Constitution. So Article 32 and Article 226 talks about. Okay, what is Article 32 about? Remedies, which is respective with that of fundamental rights. Then Article 226, High Court. Okay. So the fundamental rights cannot be amended, whereas legal rights can be amended. Is that true? We have amended fundamental rights as well. சரி, புரியல. சரிங்க. இப்ப அதுல இருக்காது. இல்ல இதுல இந்த கொஸ்டின்ல இப்ப அது வந்துச்சான்னு கேட்டேன். See, okay, we'll discuss about that. You keep it like that. See, right இருக்கக்கூடாது. See, fundamental rights cannot be amended ன்னு இருக்கு. Fundamental rights are amended. 42nd Amendment Act, 44th Amendment Act, all these were amended using fundamental rights. Okay, I have a doubt. What is constitutional right? So, okay, you tell me what is the difference between a fundamental right, constitutional right, and legal right? Okay, what is the difference between legal rights and constitutional rights? Legal rights na enna? யோசிச்சு சொல்லுங்க. No, not like that. என்னாச்சு? What is legal rights? Legal rights are, see, if fundamental rights given especially under part 3, first thing, constitutional rights are those rights that are given inside the constitution. Legal rights, any statutes or legislations மூலமா create பண்ணி you can have certain rights. That is legal rights. Legal rights, though it can be by some other means, you can ensure that it can be protected by constitution. It can be or maybe. அதுக்குள்ளே நம்ம போல. But it is, அது வந்து constitutional just like that. Are we protecting it? Are we protecting that? புரியல. See, the question is both legal rights and fundamental rights are protected by the constitution. Both are legal rights are. Okay, keep this question as a whole. We will discuss it. Okay, just keep that as a whole. Okay, next. Consider the following statements with respect to fundamental rights. Fundamental rights are meant for promoting the ideal of political democracy. True. They operate as limitations on the executive and not on the legislature. Correct? What is that article which places restrictions on legislature as well? Judicial review is there. If any law that has been passed is like in contravention to the fundamental rights or with respect to the basic structure of the constitution, judiciary can declare it unconstitutional. So it operates as limitations both on the executive as well as the legislature. Next, which of the following are the features of fundamental rights? They strike a balance between individual liberty and social control. There are some fundamental rights that are available against the arbitrary action of private individuals. There are some fundamental rights that are available only to the citizens. All the fundamental rights are self-executory. Which fundamental right is self-executory? Is any fundamental right self-executory? What is it? What is the meaning of self-executory? Just by the அந்த ஆர்டிகல் இருக்கிறது it is like executing. நீங்க தனியா இன்னொரு law வந்து நீங்க மேக் பண்ண வேண்டாம். That is what is known as self-executory. Is there any fundamental article which says that it is self-executory? What is that article? If there is, then what is it? Huh? See, in these things you can check if the article is specifying that the parliament can make the law to enforce this அப்படின்னு வந்துச்சுன்னா then which shows that it is not self-executory, rather the parliament should make a law. For example, with respect to this abolition of untouchability, we have what law? See, here it says like, see, parliament may by law, which means it is not self-executory. Clear? So in this, all the fundamental rights are self-executory, it is wrong. Okay. Next, 17th one. The executive and legislative organs of the union government, executive and legislative organs of state government, local authorities such as municipalities and panchayats, statutory or non-statutory authorities like LIC, ONGC, and SAIL. Which of the above institutions comes under the definition of state under Article 12 of the Constitution? The state includes the government and the Parliament of India and the government and legislature of each of the states and all local or other authorities within the territory of India. Within the territory of India itself, then all the things will come or under the control of the government of India. இவ்வளவுதான் கொடுத்திருக்காங்க. நம்மளுக்கு வந்து சம்டைம்ஸ் என்ன ஆகும்னா authorities within the territory of India ன்ற ஒரு ஆப்ஷன் கொடுத்திருந்தாங்கன்னா you might get confused. Sometimes the question will come like that only. Authorities within the territory of India, which means they are also included as state. Huh? See, that is territory of India. That is territory, right? Embassies, the ships that are lying even in high seas, all these comes as territory of India. அது வந்து எக்கானமில நம்ம சொல்லுவோம். GDP calculate பண்ணும்போது territory of India ன்னு வரும்போது அதெல்லாம் சேர்ப்போம். எக்கானமி இதையும் Okay, in India, judicial review implies. What does judicial review implies? The power of the judiciary to pronounce upon the constitutionality of laws and executive orders. Second statement, to question the wisdom of the laws enacted by the legislature. Will that come? No, whether it checks whether it is constitutional or unconstitutional or whether it is in contravention with the basic structure of the constitution. That is what they do in this judicial review. Okay? Can this come? The power of the judiciary to review all the legislative enactments before they are assented to by the president? See, once this happened, like once the law is being passed in Lok Sabha, but it is not even assented by the president. But before that itself, they went to the Supreme Court against that law. Then the Supreme Court said, let that law becomes into an act. It is just in a bill stage. It is yet to become an act. Then we can check for this whether to check whether it is constitutional or unconstitutional. So before that, the judiciary never comes into picture. Okay. The power of the judiciary to review its own judgments given earlier in similar or different cases. What is it about? Judiciary, the court on records, you see like certain things, in that it comes. Clear? Next, 19th one. The rule of law is embodied in the Article 14 of the Constitution of India. The Supreme Court held that the rule of law comes under the basic structure of the Constitution. In India, there is no exception to the right to equality, which is an absolute right. What is an absolute right? What is an absolute right? So what are the exceptions given in right to equality? புரியல. Third option correct. Oh, third, in India there is no exception to the right to equality. ஒரே ஒரு நிமிஷம். See, under right to equality, what are the articles included? Right to equality க்கு என்னன்னா வருது? So, Article 14, Article 15, 16 and 17. 18. Okay. 3. Okay. Clear? So, is there any reasonable restrictions there? We have certain exceptions, right? Nothing in this article shall prevent the state from making any special provisions. In right to equality, we are giving special provisions to children and vulnerable sections. To women, we give that. Then those are exceptions. It is not an absolute one. We are not saying everyone as equal. Rather, we have certain these kind of privileges. Okay. These are some special provisions that we are giving to ensure there is equity. Okay. Here, special provisions for women and children. Then for advancement of any socially and educationally backward classes. Then economically weaker sections. Clear? So there are exceptions. It is not an absolute right. Right to equality is not an absolute right. Done. Next, consider the following statements with respect to the right to equality. Equality before the law is a positive concept, which means the absence of any special privileges in favor of any person. Where equals and unequals are treated differently, Article 14 does not apply. Where equals and unequals are treated differently, where they are treated differently? In Article Article 15, that we actually differentiate, right? Women, children, then socially and educationally backward, then economically weaker sections, we differentiate. That is under Article 14 is not coming there. Whereas then what? Yes. So Article 14 does not apply there. First thing. Next, equality before the law is a positive concept. Is that a positive concept? Which means the absence of any special privileges in favor of any person is not a positive concept, right? See, equity and equality, which is the positive and which is the negative one? That is an affirmative actions that we take to ensure equality. Yes. Next, a legislation that confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of the application of law violates which one of the following articles of the Constitution of India? See, if we provide, if a law has been created which provides like a uncontrolled or unguided authority, means like he's giving all kind of power is being given to one person, then what is it? What is it like contravention to? அது எதுக்கு அகேன்ஸ்டா இருக்கு அப்படின்னு கேக்குறாங்க. Right to equality தானே? That is Article 14. Article 14, everyone should be equal in the eyes of law, but here we are ensuring that one person is getting more power than any other persons. Clear? In the matter of the application of law, violates which one of the following articles? See, இது பார்க்கும்போது கொஞ்சம் ஒரு மாதிரி கன்ஃபியூஷனா இருக்கும், but it is as simple. ரொம்ப சிம்பிளா ரீட் பண்ணுங்க. Don't go into the details. Administrative authority, legislative, don't go into such things. Just read it as a simple thing. If some power is being given to one person than others, then what it is controverted to? Answer is simple. Article 14, which talks about right to equality. What happened? Okay. Then consider the following statements with respect to right to equality in the Indian Constitution. The concept of equality before law is of American origin, while the concept of equal protection of law is taken from the British Constitution. Interchanged. See, this is a usual way of UPSC doing things. What they do is like they will keep like two things and they will just interchange and keep it. Okay, just take a moment. Even if you don't know it, மாத்தி போட்டு பாருங்க இது கரெக்டா இருக்குதா அப்படின்ற ஸ்டேட்மெண்ட்ஸ் வந்து just check it out. It mostly it is wrong. Okay, then the rule of equality before law is absolute in nature. Is it absolute? Then what are those exceptions? Diplomats, for presidents, governors, even they are not equal before law. In case with respect to civil, when they are in office, they are not supposed to start any kind of inquiry. If it is matter of criminal, only after certain kind of a notice, we can do the inquiry itself. Clear? So these are certain things. What is on the diplomat convention in a Vienna Convention? They are protected under Vienna Convention. So if the diplomats, if they are coming here and if there is any case of murder or something against them, we cannot arrest them. Rather, we can ask them to go out, but rather we cannot arrest them because they are protected under this Vienna Convention. With reference to Article 16, consider the following statements. It is confined to appointment to an office under the state. Under this article, the state cannot grant reservations in the promotion. Can the state grant reservations in the promotion? இவ்வளவு நேரம் இப்படி காமிச்சிட்டு இருந்தேனே அப்ப கூட வாசிக்கலையா யாரும்? So what is it? Can promotion be given? See, நீங்க வந்து எப்படி தெரியுமா நிறைய பேர் ஆன்சர் சொல்றீங்க, அதுல என்ன ஆப்ஷன் கரெக்டா இருக்கோ யூ ஃபிக்ஸிங் யுவர் செல்ஃப், அதுதான் ஆப்ஷன் கரெக்ட்ன்றது. I told you yesterday also, go to your bar constitution. அதுல போட்டிருக்குதானே, in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of the scheduled caste and the scheduled tribes. It is there. Promotion is there. Provided it should not affect the, what is that case name? Indrasani case. புரிஞ்சுதா? See, just blind எதையும் follow பண்ணாதீங்க. Go to the bar constitution and see. If you have any doubt, you will get a clear, credible and legitimate answer when you look into the bar constitution. சும்மா வேற ஏதாவது ஒரு வெப்சைட்ல போயிட்டு தேடாதீங்க, or some are going to ChatGPT and searching for the answers, and most of the time or 75% of the time it is going to be wrong. Okay, it will assume something and give. So for this, for especially with related to articles or stuffs, please go to bar constitution. Clear? Next, clear hai? So under this article, the state cannot grant reservations in the promotion. Can the state grant? Yes. Next, consider the following statements with respect to Indrasani case. It upheld the validity of the impugned executive order which provided 27% reservation of jobs to the OBC under the provision of Article 16 Clause 4. The total reserve quota should not exceed 50% except when warranted by extraordinary situations. Both the statements are right. Okay. See, there is this Mandal case அப்படின்னு சொல்லிட்டு வருவாங்க OBC reservations. So there are like 2-3 cases associated with that. Okay. When we say like judgments, I'll try to cover those things. Just know this one, like that it is Indrasani case where it granted like 27% of reservations to OBC and the maximum limit is 50%. Under extraordinary circumstances, it can be increased. Example is Tamil Nadu. We have around how much percentage? 69% reservation. Okay, which of the following statement is correct regarding Article 17? It abolishes untouchability and its practices in any form. Correct தானே? ஆமா, correct தான். For your kind information, I didn't mark these answers. Okay, untouchability has been defined under Article 17. No, leave it. It is available only against the state. No, against private citizens as well. So the second and the third statement is wrong, and the answer is 1 and 4. The fourth statement, it is implemented by the Protection of Civil Rights Act 1955, which means it is not self-executory. Rather, we need an act to ensure that that it is enforceable. Clear? Now this one. Consider the following statements in respect of Bharat Ratna and Padma Awards. Bharat Ratna and Padma Awards are titles under the Article 18(1) of the Constitution of India. Yes or no? Yes, sir. See, military and academic distinction alone are considered as titles. Rest all, no, it is not, it should not be used at all. Okay. But certain people are using, that is against this article. It shouldn't be used. Okay. First thing. Next. Batma Awards, which were instituted in the year 1954, were suspended only once. Yes? Okay, when and all it was suspended? Okay. How many times was it suspended? One time. Hmm. See, first what happens is like from 1977 to 1980, during that time, Morarji Desai, former Prime Minister, he said that there is no relevance of these kind of awards, so we can suspend it. That is one time it happened. The other one being from 1992 to 95. Okay, that is the second time it was suspended. Clear? See, the first suspension occurred in 1977 when fourth Prime Minister Morarji Desai questioned the award's relevance. The suspension was lifted in 1980 when Indira Gandhi became the Prime Minister. Okay. The second suspension occurred in 1992 when two public interest litigations were filed in the High Courts of India. They challenged the awards as title under Article 18 of 1 of the Constitution of India. The Supreme Court restored the awards in 1995. Clear? What are the things included in Batma Awards? Bharat Ratna யாருக்கெல்லாம் கொடுப்பாங்க? There are certain criteria, right? Conditions இருக்கு இல்லையா, 4-5 இது சொல்லுவாங்கல்ல. Bharat Ratna, what are those conditions? Whether there is any monetary grant in Bharat Ratna? Yes or no? See, the reason is should have made extraordinary contributions in field like arts, literature, public service. அதுல ஒரு 4 வார்த்தை இருக்கும். And once a case also came that when Sachin Tendulkar was given Bharat Ratna, they asked questioned their validity. How can a sports person receive when these are the criteria for to give the Bharat Ratna? Then they, what did they say? போய் செக் பண்ணி பாருங்க, போய் செக் பண்ணி பாருங்க. Okay, how sports came into that category? Already I have told this once in the class. Just go and check it out. Clear? So the number of Bharat Ratna award is restricted to a maximum of 5 in a particular year. Not correct. Not correct. Not correct. Okay. All the 3 are not correct. Clear? Because that it is, though it can be restricted to a maximum number of 5, times it is crossed 2. Okay. Next, 27. It protects both internal and external movement of the citizens. Under the provision, the entry of outsiders in tribal areas is restricted. Which of the above statement is or correct with respect to right to movement as in Article 19? Internal movement, external movement. What is internal movement, external movement? Within the country and outside the country. Outside the country is protected under Article 21. Okay, then under the provision, the entry of outsiders in tribal areas is restricted. Yes, we have that. Clear? For the protection of the interest of any scheduled tribe. Next. Which of the following statement is correct regarding Article 20, protection in respect of conviction of offences? No ex post facto law shall be enacted whether in civil or criminal matters. Only in ex post law fact எதுக்கு வரும் எதுக்கு வராது? Civil எதுக்கு? Criminal no ex post facto law. அதாவது முன்னாடி இதை வந்து நீங்க பண்ண முடியும். Retrospective you cannot enforce any law with respect to criminal. Whereas in civil you do have that. Mostly we do that in taxations. The Vodafone case நடந்துச்சு ஞாபகம் இருக்கா? That is retrospective taxation they have done. Those are civil matters. Okay. So in both civil and criminal that doesn't happen. Okay. Only in no ex post is only for criminal. Now, protection against self-incrimination covers protection against giving thumb impressions and blood specimens. No, we are bound to give that. Okay. Next, in case of corruption charges against a public servant, either the court or department should take action to avoid double jeopardy. There is a specific statement which says departmental action is different and the court action is different. And that doesn't fall under double jeopardy. What does double jeopardy means? Like convicting the person twice for the same mistake that they have done. Okay. But here that is not the case. This is a disciplinary action taken again from the departmental side. This is from the judiciary side. Okay. Both are different. Now, 29th. Right to privacy is protected as an intrinsic part of life, right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Article 14 and the provisions of under the 42nd Amendment to the Constitution, Article 17 and the DPSP in Part 4, Article 21 and the freedoms guaranteed in Part 3, Article 24 and the provisions under the 44th Amendment. This is as simple. Right to privacy, it is Article 21. Actually, 2 times this question came with respect to right to privacy. And what is the case? See, certain times what happens is when you are very confident that this is what it is, you will overlook the options and you might put it wrong. So, தெரியுதோ தெரியலையோ நல்ல தெரிஞ்ச question ஆனாலும் it is wise to read the question once and read all the options and then go to the statement and mark it as right. Clear? எடுத்த உடனே இதுதான் அப்படின்ட்டு முடிச்சுட்டு read மற்ற statements read பண்ணாம போயிடாதீங்க. Okay? Next, right to privacy is protected under which article of the Constitution of India? Article 21. Which of the following rights are a part of the right to protection of life and personal liberty? Okay, right not to be driven out of a state. Right not to be driven out of a state. Right to travel abroad. Freedom of silence. Right to the road in hilly areas. Silence varuma. Freedom of silence that doesn't come under this article. Article 19. Okay, freedom of silence come under Article 19. That's why this is wrong. Okay. Next, which article of the Constitution of India safeguards one's right to marry the person of one's choice? அதுக்கப்புறம் திருப்பி அதை மாத்தினாங்க. எனக்கு அது மட்டும் ஒரு சின்ன டவுட் இருக்கு அதுல. நான் கேஸ்ல பார்த்துட்டு I'll tell you which case it is. Okay. Article 21. As of now, it is Article 21 and which guaranteed like right to marriage. Okay. Consider the following statements with respect to the right to education in the Constitution. The 92nd Constitutional Amendment made the right to education a fundamental right. Article 21A Constitution guarantees the right to receive education in the mother tongue. அப்படியா? எல்லாமே அதுல மதர் டங்கும் கொடுத்திருந்தாங்க. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. அவ்வளவுதான். இதுக்கு மேல வேற எதுவுமே அதுல கொடுக்கல. கரெக்டா? மதர் டங் இல்லையா? Nothing has been given there. Right? And it is done by which amendment? Clear? 86th Amendment Act 2002. Next, the 86th Constitutional Amendment Act of 2002 added articles to which of the following provisions of the Constitution of India? All the three. 86 is with respect to education. What they have done, first it was like in fundamental duties, we had like, we have to add what? Wait. See, this is what it is. This amendment is a major. See, education for all. It added new article, listen. Article 21A that states shall provide. Next, Article 45 in Part 4. Okay. The amendment changed the matter of Article 45 in DPSP. Now it says that the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Clear? முதல்ல எப்படி இருக்கும்னா pre and compulsory education for children அப்படின்றதுதான் first DPSP ல இருந்தது. 86th Constitutional Amendment Act la fundamental rights la they brought 21A which specifies 6 to 14 years compulsory education. Now if it is fundamental right, it becomes justiciable and enforceable. Now they wanted to change to DPSP because DPSP la irukradha nama enforce பண்ணியாச்சு. Now what they do, they changed into early childhood care. Okay. Then in 51A, which is fundamental duty, they added, it shall be the duty of every citizen of India who is a parent or a guardian to provide opportunities for education to his child or ward between age of 6 and 14 years. It is a fundamental right which you can get it, and it is the duty of the parent or the guardian to send the child for education. This is how these three things are interlinked. Prida? So 86th, like right to education brought in changes in all the three fundamental rights, DPSP and fundamental duties. Correlate பண்ண முடியுதா ஒரு சைக்கிள் மாதிரி வருது இல்லையா? That is what it is. Any doubts here? Constitutional Amendment Act la adla மாத்திருக்காங்க தானே. They have taken that and they have added this, right? See, don't think too much like this. That is what I'm telling. Over thinking வந்து பண்ணாதீங்கன்னு சொல்றது வந்து இதுல ஆட் பண்ணல, இல்ல சப்ஜெக்ட் மேட்டர் மாத்திருக்காங்க, கான்ஸ்டிடியூஷன் அமெண்ட்மெண்ட் பண்ணி தானே மாத்திருக்காங்க. வாட் எவர் இட் இஸ், ஏற்கனவே இருந்த ஒரு சப்ஜெக்டை எடுத்துட்டு இட் இஸ் லைக் they added something. And that before இருந்தது இதுல ஆட் இல்ல, அது அப்படி ரிமூவ் பண்ணிட்டாங்க இல்லையா? Then you are telling that they should have removed Article 45 and put it as Article 45A. That is what you are telling. Okay, don't think too much. That's what I would suggest. Even if such is the case, then fundamental duties may வரக்கூடாதுல்ல. சரி சண்டை போடாதீங்க. பயமா இருக்கு. In 51A fundamental duties அவ்வளவுதான். இதுல இது மட்டும் தானே. இது தனியா ஆட் பண்ணிருக்காங்க, அதனால இது ஆனா இது no comments. Okay. See, 86 Constitutional Amendment இந்த மூணு இதுலயுமே changes வந்திருக்கு. பொதுவா நான் வேற எதுவுமே நான் சொல்லல. Next, which of the following are envisaged by the right against exploitation in the Constitution of India? Prohibition of traffic in human beings and forced labor, abolition of untouchability. Will that come in right against exploitation? Then protection of the interest of minorities, prohibition of employment of children in factories and mines. See, right against exploitation, only 2 articles. prohibition of traffic in human beings and forced labor, prohibition of employment of children in factories. Clear? Abolition of untouchability. அது எந்த இதுக்குள்ள வரும்? Right to equality. Then this one, protection of the interest of minorities, it comes under cultural and educational rights. Okay va? அது வேற டாபிக் கீழ வரும். ரைட் அகெயின்ஸ்ட் எக்ஸ்ப்ளாய்டேஷன்ல அது வராது. புரிஞ்சுதா? இதுல ஏதாவது டவுட் இருக்கா? See, they have specified fundamental rights ஒவ்வொரு பர்டிகுலர் ஹெட்டிங் கீழ ரெண்டு ஆர்டிகல்ஸ் அந்த மாதிரி ஸ்பெசிஃபைவா பிரிச்சு வச்சிருப்பாங்க. You should be knowing that heading and what articles come under that. Right to equality from article 14 to article 18 you have. So if you take this article, cultural and educational rights, you have like two articles, article 29 and 30. Okay, because this one has been omitted, so other include panala. Okay, 29-30 is under this cultural and educational. Then this one, right to constitutional remedies, adukku keela ethana irukku. Right to freedom of religion. So 4 articles. Clear? So endenda 4 articles endenda heading keela varudungrada therinju vechukonga. Next, which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Ama. Right to equality. Don't see these answers. It is tomorrow I'll tell them not to mark any answers. Okay, I'll tell them not to mark it, and the answer for this is right to equality. So right to equality, abolition of untouchability. Okay va? Consider the following statements with respect to cultural and educational rights guaranteed by the Constitution. The scope of Article 29 is not restricted to minorities only. All minorities shall have the right to establish and administer educational institutions of their choice. We'll go to the answer pakavanda. We'll go here. So cultural and education rights, right of minorities to establish and administer educational institutions. Now we'll go here. Here what they say? Any section of citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So the first one talks about the language, and the second one with respect to no citizen shall be denied admission to any educational institution maintained by the state or reserving grounds only of like religion, race, caste, language or any of them. So it is not restricted only to religion. That is what the question says, right? Not restricted to minorities only, because it says what? Any section of the citizen. For example, if you take in Tamil Nadu, who is minorities, we have certain communities as minorities. If you go to this Jammu and Kashmir, who are minorities there? We consider in the whole of India, we consider Muslims, Christians, Jains, Parsis, they are all minorities. Whereas in Jammu and Kashmir, who is in minority? Hindus. So it will be varying from state to state. Clear? So it is not based on which minorities, rather it is any section of citizens. And the second one, all minorities shall have the right to establish and administer educational institutions of the choice. Yes. என்ன இருக்கு? முடிஞ்சதா? Right to conserve distinct culture is a fundamental right guaranteed under. இங்க நம்ம பேசணுமா? Article 29, that is cultural and educational rights. Having a distinct language, script or culture. All these things comes. 3 things: language, script or culture. All these 3 should be protected, and it is right to minorities. இந்த 3 இதுல இது வந்துதான் அதுல வருது. Okay, rather they could have given us cultural and educational rights and கொடுத்திருந்தாங்க. It would be much more correct. Then which of the following articles are associated with ensuring liberty in the Indian Constitution? Article 21. See, that is the most like interpreted article, Article 21. All the things will come there. Next, Article 22. What is it talking about? Article 22. Protection against arrest and detention. Next, Article 19. Freedom of speech and expression. All these things will come, like assembly, association, movement, residing, everything will come there. Okay. So all these three things ensure the liberty. Next. Consider the following: President's rule, national emergency, martial rule. Which of the above special circumstances has or have an effect of the fundamental rights of the Indian citizens? Fundamental rights appo endha idu marum? Okay, when under what circumstances these things will get changed? Under President's rule நம்ம fundamental rights வந்து ஏதாவது restricts பண்ணுவோமா? Why, when do we call it as President's rule? தெரியும்ல. See, I showed you this with respect to national emergency only under when there is external war or aggression. During that time, fundamental rights will be changed. Whereas in President's rule will come even in case of like what? Hung parliament. I'm sorry, if there is hung assembly or when there is constitutional, like law and order situation is deteriorating, under that circumstances, President rule will be enforced. Under those times, no changes in the fundamental rights will be done. Only changes when it happens is national emergency and also two things, external war or aggression. Under no other circumstances, fundamental rights will be changed. Clear? Next, with reference to the writs issued by the courts in India, consider the following. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Mandamus will not lie against a company even though it may be a government company. Any public-minded person can be a petitioner to move the court to obtain the writ of quo warranto. See, the first ரெண்டு question எவ்வளவு contradictory இருக்குதுன்னு பாத்தீங்களா? If the person is, if it is a private organization and during doing a public duty, then mandamus will not lie if it is a private organization. Only private organization, mandamus will not be enforced. But the private organization is doing public duty, then mandamus will come into place. Whereas the second statement says, it not against a company, even though it may be a government company. How will that happen? புரிஞ்சுதா? Private organization இருக்கு and it is doing only private duty. அதுல போய் நீங்க mandamus பண்ண முடியாது. But the private government is now outsourcing certain things and they are doing public duties. Yes or no? Then under that circumstances, we can give mandamus to them. If the private organization is doing a public duty, we can give mandamus. But the second statement says, even if it is a government company, we cannot even give mandamus. Private organization doing public duty itself, we are giving mandamus. Then how can we not give a mandamus to a government company? புரியல. If ஒரு பிரைவேட் கம்பெனி ஒரு பப்ளிக் டியூட்டி பண்றதுக்கே நம்ம மேண்டமஸ் கொடுங்கன்னு நம்ம சொல்றோம். அப்ப கவர்மெண்ட் கம்பெனிக்கு கொடுப்போமா மாட்டோமா? கொடுப்போம் தானே? அவ்வளவுதான், சிம்பிளா தானே இருக்கு. ஏன் இவ்வளவு திருத்திருன்னு நினைக்கிறீங்க? So any public-minded person can be a petitioner? Yes. For quo warranto. So the second statement is wrong. If it is a government thing, we can give mandamus. We can command them to do certain things. அதுதான். That is only with respect to government company. Next. Writ of prohibition is an order issued by the Supreme Court or High Courts to see which is a preventive and a curative. Writs preventive, curative no ஒன்று தெரியுமா? What is it? இது யாரு பேசுறீங்க? ஓகே. No. In writs, there is writs சொல்லுவாங்க இல்லையா? Like we have how many writs? Habeas corpus, mandamus, quo warranto, and certiorari, right? And prohibition. Yes. Okay. Now you tell me there are like 5 things are there. Now there is one writ which is seen as a preventive one, and the other one is seen as a curative one. Prohibition is preventive because it prevents the lower court from providing any kind of an order or something. It is a preventive one. Then what is the curative one? In certiorari, what will happen? என்ன பண்ணுவாங்க? The higher court can quash the okay, இது மட்டும் தான் இருக்கு. See, in certiorari, what happens is they will actually squash the order passed there itself. They will not only prohibit them, rather they will squash the order. That is known as curative. That is the difference between preventive and curative. Okay, preventive is with respect to only prohibition, whereas with curative, it is certiorari. Next. 43rd, which of the following statement is true of the fundamental duties of an Indian citizen? A legislative process has been provided to enforce these duties. They are correlative to legal duties. Is there a legislative process has been provided? Of course, there are certain things. ஆனா இந்த இதுக்கு இந்த இடத்துல எங்கேயா நம்ம கொடுத்துக்கோமா ஃபண்டமெண்டல் டியூட்டிஸ்ல? ஆமாவா? See, these are just duties and there is no legal process associated with that. Taniya rules ஏற்கனவே இருந்தது, we can like interrelated, but rather like when fundamental duties came into being, they didn't come up with any legislative process for imposing these fundamental duties. So the first statement is wrong. They are correlative to legal duties. Legal duties, if you are not doing it, what will happen? You will be like penalized, penalty, fines, ellame varudha. Whereas when you are not doing these fundamental duties, are you getting penalized for them? நீங்க எக்ஸ்ட்ரா ஏதாவது பே பண்றீங்களா? ஃபைன்ஸ் தான் பே பண்றீங்களா? No, right. So they are not correlated to legal duties. If you are not wearing your helmet, you are being fined. Yes, but whereas here, if you are not cherishing and following the noble ideas of the freedom which inspired our national struggle for freedom, if you are not cherishing it, what will happen? Are they putting any fine for you? Are they sending you to jail? No, right? They are not imprisoning or doing you anything, right? That is what it is. Doesn't correlate with legal duties. Then, in the context of India, which one of the following is the correct relationship between rights and duties? Rights are correlative with duties. Rights are personal and hence independent of society and duties. Is that true? Second one. Independent of society, rights. In each and every time we talk about this reasonable restrictions, we talk about sovereignty, unity of India, integrity, then like international relations or peace, morality, order, health, all these things are with respect to society. Next, rights, not duties, are important for the advancement of the personality of the citizen. Is that true? Which is important for the advancement of the personality of the citizen? Okay, duties, not rights, are important for the stability of the state. Is that true? All these are included. All these are important. So the best option would be rights are correlated with the duties. Next, which one of the following statements is correct? Rights or claims of the state against the citizen. Does that state is claiming the rights? Rights or privileges which are incorporated in the constitution of a state. Rights or claims of the citizens against the state. Rights or privileges of a few citizens against the many. It'll be negative. You can just omit it. Okay. And rights are not kind of a privileges. Rather, they are just you ask just being the citizen of this country. Okay. Which you claim to be. Next. To uphold and protect the sovereignty, unity, and integrity of India is a provision made in the ஓகே சி இது தெரியுமா? இது ஞாபகம் வச்சிருக்கீங்களா என்ன ஆர்டர்ல வரும்னு? Next, in the context of the Indian Constitution, consider the following statements regarding fundamental duties. Fundamental duties are confined to Indian citizens only. Yes. The Constitution does not provide any legal sanctions against their violation. Yes. The Constitution does not provide itself fundamental duties. If you are not following, this will happen. It doesn't give such things. Okay. So both 1 and 2 are right. Which of the following are the fundamental duties under Part 4A of the Constitution? To develop the spirit of inquiry and reform, to respect the national flag. Okay, here, come. To respect national flag and national anthem, then noble ideas, cherish and follow the noble ideas. Then here, spirit of common brotherhood, then value and rich heritage. Then where is inquiry? H, spirit of inquiry, and this, and the other one is to cast a vote. Will that come? Spheres of individual and collective activity. Okay. But the Swaran Singh committee, right, they suggested to include this to cast a vote. If they change the question, like it was recommended, Abdina, it might be true. Okay, to cast a vote. But the question is not that right now. Next, with respect to the roles performed by fundamental duties, consider the following statements. It is a check against anti-national and anti-social elements. It is a source of inspiration for the citizens. They help the courts in examining and determining the constitutional validity of a law. இது ஹெல்ப் தான் பண்ணணும்னு கொடுத்திருக்காங்க. இட் மேண்டேட் பண்ணல. நீங்க ஓவரா உடனே இப்படி பாக்காதீங்க. ஓகே. Okay, hold that question. Now, right to vote and to be elected in India is a constitution. அது ஃபண்டமெண்டல் ரைட்டா கான்ஸ்டிடியூஷனல் ரைட்டா? கன்ஃபார்மா? என்ன ஃபண்டமெண்டல் ரைட்டா? லீகல் ரைட்டா? UPSC key is constitutional right. UPSC key is constitutional right. அத வந்து நீங்க படிச்சிருந்தீங்கன்னா நீங்க போட்டிருப்பீங்க. அந்த ஃபுல் இத அட்லீஸ்ட் ஒரு தடவையாவது நீங்க படிச்சிருந்தீங்கன்னா நீங்க போட்டிருப்பீங்க. See,